Hey everybody, this is Attorney Kenneth Stevens from the law firm Stevens PLLC, and today what I want to talk to you all about is a provision in the Texas Property Code, specifically the Mechanics Lien statute, that I think a lot of people overlook. Now, when you think about notices under the Mechanics Lien statute, you think about all those convoluted notices sent by the 15th day of the third month or 15th day of the second month, or everything needs to be sent by certified mail, return receipt requested, and all this different stuff. And to a certain extent, that is true. By sending these things via certified mail, or by registered mail, you pretty much put yourself in the best position to be able to prove up compliance with the statute. But what happens when you have a situation where you may not know if you have the correct address, or you may not know if you have the correct party, or maybe it's just a situation where time is very tight and you can't make it to the post office. I want to point out to you that if you look at chapter 53.003, there's some language in there with regard to notices that says specifically that as long as written notice is received by the party that it was intended to be delivered to, if you can show that it was actually received, then the way that it was sent, the way that it was delivered, is immaterial. So what does that mean? As long as you send written notice and you can show that the person got it before the deadline, it sounds like you meet the standard, right? Sounds like you meet the property code standard. And I've actually seen some case law that has addressed this. So I would encourage you that if you can't make it to the post office, get it in writing, get a written notice together that's compliant or that substantially complies with the property code, and either just send a courier over to deliver it personally, send it via email. Just find a way to get written notice to the intended party and try to get some kind of confirmation from them that it was received, whether it's something signed from a courier or whether they just respond to the email saying, hey, what is this? If you do that, I think you at least have an argument that you complied with the code, whereas if you don't send anything at all, you're pretty much SOL. Anyway, I hope this is helpful. You all share it as usual, and as always, happy building.